the Nnamdi Kanu's freedom case has seen another major development. There's been another major development, and this time it involves the Supreme Court and the Tinubu. It involves the Supreme Court and the Tinubu, because people are not sleeping. People are not sleeping on this matter of Nnamdi Kanu. Let's now focus on it. Nnamdi Kanu's legal consultant, Njoko, slammed Supreme Court over IPOB leader's case, caused December 2023 remitter constitutional heresy, that Supreme Court has committed what can be called a heresy, because they saw a right judgment in the Supreme Court under Tinubu, and they decided to close their eyes to the truth. Let's now move on. Barrister Njoko Jude Njoko, a legal consultant of the detained leader of the indigenous people of Biafra, IPOB, Mazi Nnamdi Kanu, has slammed the Supreme Court. The Supreme Court decision of December 15, 2023, describing it as an unlawful and constitutionally void remitter of Mazi Nnamdi Kanu's case. You see, whenever a judgment is made, it sets a precedent. And if a wrong judgment is made, it means that that nation that within which that wrong judgment was made could go on making several wrong judgments. The way they are handling Nnamdi Kanu's case is setting a precedent that might destroy the legal foundation of the very nation, Nigeria. In a document titled "A Devastating Critique," the Nigerian Supreme Court's unlawful remitter of Mazi Nnamdi Kanu's case, the inviolability of Section 36 of Section 9, immunity, and universal doctrine of finality of appellate discharge, Njoko, consultant to the Mazi Nnamdi Kanu Global Defense Consortium, accused the Apex Court of committing a blatant constitutional perversity that undermines the rule of law and the supremacy of Nigerian constitution. This man is saying that the way Nnamdi Kanu's case was handled perverts the law. The lawyer said the Supreme Court decision to remit a charge already extinguished by the Court of Appeal October 13, 2022 judgment, which discharged Kanu of all counts, was jurisdictional impossible and a global jurisprudential heresy. That a court of competent jurisdiction already said Nnamdi Kanu is acquitted, Nnamdi Kanu is freed, Nnamdi Kanu should be released, no court in Nigeria should try him. For the Supreme Court to now come and upturn that very judgment without that judgment being obeyed in the first place, this Njoko is saying that it was a jurisdictional impossible and a global jurisprudential heresy. While it is accepted that the law is what the Supreme Court said it is in the interpretative hierarchy, this maxim yields inexorably to the supremacy of the Constitution under Section 1, subsection 1, and Section 1, subsection 3. The Constitution is the supreme law, not the Supreme Court. He stated, yes. Some people say, what did the Supreme Court say on a matter? But then, the Constitution of a nation supersedes the Supreme Court. And the people supersedes the Constitution, because the Constitution derives its power from the people, and the Supreme Court now derives its power from the Constitution. That is the sequence. Supreme Court derives their power from the Constitution, and the Constitution derives its power from the Nigerian people. Citing Section 36, subsection 9 of the 1999 Constitution, Njoko argued that once the Court of Appeal discharged Nnamdi Kanu, the defendant became constitutionally untouchable for the same offenses. He said that the provision guarantees non-derogable immunity from further prosecution after a valid discharge by a competent court. Even if they were to appeal that case, they should have obeyed it first. Then they can now appeal. Remember, if you believe in Nnamdi Kanu should be free, come under the comment of this video and say, Tinubu releasing Nnamdi Kanu now. Tinubu releasing Nnamdi Kanu before it is too late for Nigeria. Type it in the comment section now. The non-derogable immunity conferred by Section 36, Section 9 is self-executing absolute and beyond the reach of any judicial organ, including the apex court, that is the Supreme Court. Once the Court of Appeal pronounced discharge, jurisdiction to retry him was permanently lost. It's important you share this video. Let Nigerians, let it even get to Tinubu. They should know the truth. And sometimes it appears they know the truth, but they are so afraid of the truth that they do not obey it. The lawyer further argued that the Supreme Court, by remitting the case without reversing the finding of illegal rendition or establishing new evidence, violated the universal doctrine of finality of appellate discharge. Yes, once an appeal court discharge a matter, it is final. Before you even do some other thing, obey it first. Kanu was discharged and acquitted. It should be obeyed before you now move on. He referenced comparative common law precedent from England, Canada, and Australia to illustrate that once an appellate discharge is entered, the case terminates with absolute finality, which was what was reasonably expected in Nnamdi Kanu's case. Njoko also cited Nigerian cases such as FRN versus Ifegu 2003, Abacha versus Fawemi 2000, and Dokubu Asare versus Federal Republic of Nigeria 2007, to buttress his point that appellate discharge ends the matter finally and irrevocably. In these other cases, the one involving Asare Dokubu, the one involving Fawemi, or the one involving Ifegu, once Supreme Court says something, they obeyed it. But in Nnamdi Kanu's case, Supreme Court says something and they now choose to refuse to obey. We must move on. He said that the provision guarantees non-derogable immunity. Okay. Now, we must move on. Describing the court action as judicial overreach masquerading as appellate review, he contended that the decision effectively placed the Supreme Court above the Constitution and eroded the doctrine of separation of power. This is something to worry about. To hold otherwise is to elevate the Supreme Court above the Constitution. It swore to uphold and render Section 36, Subsection 9, a mere subjection, and Section 1, Subsection 3, a dead letter. He warned. Njoko further accused the five-member panel that delivered the December 15, 2023, because it was in that panel that they ensured that Nnamdi Kanu will keep being held. 2023 judgment of committing a second constitutional abnormality by overturning established African Charter jurisprudence that had been decided by a larger 7-member constitutional bench. This judicial subordination to binding precedent undermines institutional coherence and collapses the hierarchical integrity of the court itself. This is a lawyer talking. Please, you watching this video, if you want Nnamdi Kanu to be free, please don't get tired, don't get discouraged, keep talking about it, keep praying for him. He added that no smaller bench could lawfully overrule or modify a decision of a larger constitutional panel. Njoko declared that the remittal judgment was void ab initio for want of jurisdiction and amounted to judicial insurrection against both the Nigerian Constitution and the African Charter on Human and People's Rights, which he noted forms part of Nigeria's supreme law. It is therefore beyond question, this a barrister talking, that the December 15, 2023 remittal judgment is not only void for want of jurisdiction, but also void for judicial insurrection against the Constitution and the African Charter jurisprudence, he said. This is also why Kanu has maintained that he's not entering into a defense, because he shouldn't even be in Nigeria. He shouldn't even be in Nigerian courts in the first place. So you like this video, share this video, click on join to become a full member of our channel. And most importantly, there's another very, very important video on the screen. Click on it and watch now.